Test, 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 test. It's coming through. It's excellent. All right. This here. And just a little bit. I think that'll do it. Admit all. All right. Next, go over here. Don't yawn. Oh, don't ever yawn. I was actually asleep at 4. Of course, I was up till probably about 3, I think. Screaming kid. A lot of fun, though. All right, so chapter 5, witnesses and testimony. Okay, so we got 3 minutes. I'm going to run down the hall real quick, get some more water. We're about 3. And we have all 3. I'll wait till those keys. 4. Excellent. 1 still joining. Connecting to audio.
I said it was busy this morning.
Thank you. All right, so 1, 2, 3, 4, 5, 6, 7, 8, 4, 12. Okay, cool. Cool. So how is everyone today? Pretty good. It's a little warm in here. Is it warm outside? outside yet. So at some point, I'll have to get outside and check that out. I like warm weather. All right, so last time we reviewed for the exam, is that correct? Okay, excellent. So now we're ready to move forward into witnesses. So here today, I am going to actually use the PowerPoint because I don't remember what I need to say. And this will cue up my memory as we go. All right, so share. So here we're going to start talking about witnesses. So there's multiple types of witnesses. And they serve a number of purposes. But for the purposes of this class, there's one really, really, really important thing, one purpose that they serve. What is that relationship there between evidence and witnesses?
A witness can provide some good evidence.
Okay. Provide evidence. Okay. What else? They just provide evidence. It's typically kind of what people are meaning whenever I see that kind of phrase. Like they start thinking about the tangible kinds of things, that kind of stuff. Usually on the scene kind of things. Is that what you're thinking?
Mm-hmm.
Cool. Cool. Another big different form of evidence, testimony, that kind of stuff, right? Another thing they do in the process of the court itself, the courtroom, trial processes. Also a vehicle for admitting evidence. So as you're watching the trial itself, you're a juror participating in it if you're like a lawyer or something else. As you're bringing your witnesses up, whenever they officially get entered into the trial record, it's during that process, right? And so that's where most people would have seen if they were watching the witnesses for that. But most people don't watch it for, of course, we talked about that already. Watching the not so much a show, but trying to figure out what's going on with it at any point in time, whether you're a juror, lawyer, or just spectator kind of thing. If you're paying attention, though, you'll see that as that testimony is coming through, that's typically whenever they'll enter in your evidence, your physical evidence. Why would you do that? Why would you do it like that? Funds. I mean, you can just enter in all this stuff beforehand, like it's in the record already. Some of that stuff they do like that too. Some stuff they don't. They'll wait till the testimony is in progress. And they'll use that right there. Let's see what this thing just got me to say. Right there. It's also good where I can see they saying it's a little ways away, but I can see. Okay. Sounds like you should be in now. Okay, so as we're talking, the role of witnesses in evidence, of course, is direct, right? They'll, on the scene, they can point you to where physical evidence is. Sometimes they can do that. They might have something in their own possession they bring forward, something of that nature. They provide testimony while at the trial. I mean, they're going to say some things, typically. Doesn't always have to be like that. Sometimes if you recorded statements, things of that nature, then you start crossing boundaries between when something's testimony versus just regular evidence kind of thing, reporting. And so that's a discussion for a different class. We'll get into that so heavily here. What I want you to see is Sometimes it's a vehicle for admitting evidence. Essentially what a witness is they're a good vehicle for admitting evidence. As they're telling a story, that's when you'd want to introduce the evidence because it reemphasizes the points being made. It shows that there is something real, something tangible to back up the statements of what's being said. In that, you're getting greater weight. Here, you're using this to reinforce it. As you're doing that, the perceptions that that gives to a jury at any one point in time gonna have a bit more of an influence on it. Remember, we're talking about the value of evidence, which means it's what three things? What three things we grade evidence on? R, M, C. Royal Mounted Canadian Police. No, that's RCMP. Relevance, relevancy, materiality, how material is it, that kind of thing, and then competency. Can we admit it? Those are the big three questions. Right? Admit that in here. We're getting this testimony. That weight has a significant bearing. Okay, so we're going to talk about witnesses in general, and then we'll talk about all of that stuff as it goes. That's kind of the perspective that you would have seen if you've been watching like any real trials, depictions of trials, that kind of stuff. It's as that person saying something. Enter into evidence, firearm A, right? It's similar to one used in this murder. It's the same one used in this murder. That kind of a thing. I found it over at such and such. Here it is. So the weapon used. That kind of a thing. So you can use it as a touch point to reaffirm people's statements. That kind of stuff. So witnesses. Is it gonna? I guess not. Okay, so this one. General qualifications for being a witness. We'll talk about. Some groups are special. Start with children, kind of thing. Children are a special population in general. And so when we get into the details of that, we'll talk about how that stuff's kind of handled. Identifying factors determine the credibility of witnesses. So how credible are people? That's where that character can come in, right? So list of constitutional rights related to witnesses. That's going to be subpoena powers for the most part, confrontations, that kind of thing. And then differences between late witnesses and expert witnesses. Talk about those. Okay, read and understand Rule 7.2 of the Federal Rules of Evidence. There's put a link in there. We'll just look at that real quick. The suggestions that may be made to witnesses to answers by witness. Okay, so maybe they'll have that in there later. Okay. So here's what you need to be a witness. And there's some things here we'll need to discuss. Okay. First one, you need to know something. You need to tell the truth. And you need to be admissible again. Those 10. So we don't need to really talk about that so much. That truthfulness. We've talked about to some degree already, yes? So how is it we establish that? How do we establish someone telling the truth? Consistency. Yeah, so you get that. This is going to be long-term, maybe within the trial. Good. Consistency. Yes. What do we do? What do we have a witness do to ensure that they tell the truth? Swear on the bottom. There you go. First, it starts out with that oath. That kind of affirmation, right? You start with that as an initial start point. As you're moving through it, the trial itself, with the consistency, how it lines up with evidence, how the statements line up with other statements, how it lines up with the context and the situation, that kind of stuff. On the other end of the spectrum, This is before. After. Okay. We're looking for consistency. There's ways to check that. We have swearing beforehand, after the fact. What do we do to make sure that people are telling the truth? Ways to reinforce people to tell the truth. What ways would you look to reinforce that message? It's criminal justice system.
Incentive or
Stuff like that. Right? So this is stuff that has some real skin in the game. If you're going to be a witness, you get up there and you say something that is untruthful, you can open yourself up for perjury and other charges, whether it's contempt of court, that kind of stuff. As you get into those areas, you realize, hey, what you say does matter to some degree. Okay? When we talk about personal knowledge, here it says personal. So what do they think? What do you think they mean by personal knowledge?
Having actually witnessed the event or knowing someone who's involved in it.
something that somebody else does personally.
Something they know directly, right? And so you have to intersect that with those other facets that we talked about earlier. With whatever fact it is that they know or statement, they're going to make something that basically talking facts, that kind of thing. I know this, that's a fact. How does that intersect with those other things we were looking at? Relevancy, materiality, also competency. Like I said in here last time, we were dealing with hearsay. Everyone knows that hearsay is generally not admissible at trial because it doesn't prove anything to the facts at hand. I heard so-and-so say that this guy named David. Okay. What does that mean? Is that ever of value at all? Maybe. Depends on how it hooks into the whole situation. Right? But it's that personal knowledge. You'll see that changes a little bit in terms of what we mean. We start talking about the difference between your standard witnesses and your expert witnesses, but we'll get there. Okay, competency. Here's where we start getting it for witnesses. Not just that you can see stuff, remember, and relate it, but that duty to tell the truth. Okay. Presumption. Adults are competent. That's rebuttable. What does that mean?
All there.
Yes, that's a big, it's a standard like default assumption. You're going to see presumption. There are two types. Remember that there are those that are rebuttable and those that are not. That one's rebuttable. Right? That's where you get your affirmative defenses of, well, diminished mental capacity, mental disease or defect, something of that nature. From there, it says competency may be challenged, perceive, remember, narrate circumstances, inability to understand the book. So basically, it's just talking about those elements right there. Can you see something objectively? Can you remember it without corrupting it? Can you relate it? Again, without corrupting it. That's why the consistency is so key. Because as I ask it, X number of times, I'm going to ask it to you for the Y number of times that we meet, for the Z number of hours that we talk about it. That consistency is one that if you're trying to manage lies, can get it to come out. You can also misread it too. Oh. Next up. Okay. So whenever that's brought up, That's one that the burden on that is on the defense, because you're the one who's saying you can't stand trial, or you can't stand as a witness. So it'd be, if it's a witness itself, if you're doing, I kind of mix that up a little bit. Defense, if you're doing with defendant, competency to stand trial, that's one thing. Competency to be a witness is another. You can have someone who's not competent to stand as a witness, but is competent to stand trial. Right? You can have witnesses be competent, stand, be on the stand. But who has the burden of determining whether or not they're competent? If it's the defense or the defendant, well, it's going to be the side that puts them up. It's the other side that's going to be challenging that. That's why you'll have a number of processes involved. Those come more important when we start talking about expert witnesses, but we'll get into that. Okay. Party containing witness is incompetent, has the burden of proving the witness lacks that ability. So you have to rebut that, right? So you put them up, you'll establish that. You'll establish that with expert witnesses. You have to establish that. And if there's anything that comes in the course of that trial that shows that they can't do these things, guess what? You're doing your job as a lawyer, right? You reintroduce doubt again. Because if those people can't do this, they shouldn't be a witness. Okay. The jury can decide what effect, if any, the circumstances should have on the credibility of the testimony given by the witnesses. So that's who determines the weight given to the witness, to what's said to the evidence, the jury, unless you're on the bench trial. Next up, we'll talk about children. Children are not necessarily presumed to be competent because they're children. Diminished mental capacity, still developing. So they go through this process. Your jury goes through this process. Your witnesses go through this process, the voir dire process, questioning process, much similar to that of the jury. So you're doing the same types of questions, trying to get what you want to do. Child, you're going to be outside the presence of the jury to determine this. Let's be able to remember what occurred, tell events, and know they're being truthful. Trial judge rules on this one, right? Now, that can come in a couple of different forms, right? Is that going to be something where just their statements are given and taken in as evidence? Is that something they're actually going to stand up in that jury box or in the witness box? That's something of that nature we can stand. Those are all different determinations to be made. Different thresholds are going to depend on the context of those individual situations. Age is important, but not a determinant. Right? Some will do it by age. I mean, if you start doing with the age stuff, it's when are you held to the law? When are you held to these processes? That kind of thing is going to vary a little bit. But there's statute court rule, male children appears witness without specific age limits here. Here, they've got it presumed to be competent at that level, at the federal level. But you still have to meet with the judge to determine specifically. Age is a factor, not necessarily. It's going to depend on what actions, deeds, situations are all going to be present there. Voir dire means to speak the truth. Preliminary examination to determine whether a witness or juror is competent or qualified. So we talked about that a little bit in terms of jury at the beginning of the semester. I think it's been a few weeks. What kinds of questions do they ask jurors? Kinds of questions to determine biases, that kind of stuff. You want to get those things out.
Raising doubt, questions of raising doubt.
Yeah. And so with the jury themselves, you're trying to figure out, it's like, do you have any conflicts of interest, any reasons why you're going to be so biased you can't give a impartial verdict? It's like knowing someone who's attached to a state might not necessarily render you unable to be a juror, so long as you are separate from whatever that issue is. For example, media coverage is a common one. It's like, have you ever heard of this case before? Do you know what's going on? Well, I heard some media stories. Okay, so you've heard that. That's a potential bias. Can you set that aside and only make a determination based on the facts as they are presented in this trial? That's a yes, you stay. That's a no, you should go. Right? That kind of thing. Here, same kinds of questions to some degree. But you're gonna have a few different questioning processes here. So here, you have the oath or affirmation. You must be personally present during the trial. That's one that's kind of changed a little bit with technology, right? Because before, ooh, let me show you something funny. You guys want to see something funny? So this is where technology comes in. This is a funny one. I'll show you this one real quick. YouTube.com. We're going to say suspended driver's license Zoom. We'll go. This one's a shorter one. You'll like
Wix,
this.
one platform, any website, unlimited creation.
Mr. Harrell, are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
You stationary?
I'm pulling in right now at this second. Yes, I am.
All right. What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 4 weeks if the court would allow.
Okay. So maybe I don't understand something. This is a driver while license suspended,
That is correct, Your Honor.
and he was just driving. And he didn't have a license.
As with the charges, Your Honor, yes.
No, I'm looking at his
Yes.
record. He doesn't have a license. He's suspended and he's just driving.
That is correct, Your Honor.
Oh,
Oh, oh snap! Just wait for that realization to click in fully because it's still not there yet.
hello?
1 minute, Mr. Harris.
What do you think about that? Isn't that glorious right there?
I don't even know why he would do that.
I
So
don't get it.
defendant's bond is revoked in this matter. Defendant has turned himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond. Thank you.
Your Honor, Mr. Harris, I'll be giving you a call.
Okay.
Court calls case, People versus Maya Isom.
With me,
What do you think about that? Yeah. Yeah. So that's sometimes the stuff that happens here. So sometimes it's literal. It's like while you're literally on your way to court. I guess they ordered him back to not like you should have any trouble getting to for jail, right? You get him behind the wheel. What's going on there? Right? A lot of interesting things. That was just one of those things. You must be personally present at trial. That's something that's changed a little bit. So you get some interesting things again. Sort of like, hey, you're literally detecting more criminal activity right there at the trial kind of thing. Typically what will happen is if you're going to be a witness, you need to be personally present. If you can't be personally present, that's a problem, right? Because at that point in time, you're no longer a witness. You can't be cross-examined. You look at constitutional rights. You need to look at Fifth and sixth pretty heavy because in that one, you're also gonna have your self-confrontation. I want to say that's fifth, but I have to look. This will probably tell me here in a second. You don't get to face your accusers. You end up in a very, very, very difficult situation. If we look at that across history, that's a really bad one. Here, not only do we have to tell you what you're accused of, we also have to let you face those who accuse you. And so, cross-examination. You do not tell the truth, perjury. Refuse, and that's contempt. So you have to talk. That's the other side of it. So if I said subpoena, what is a subpoena? If you're going to be a witness, you're going to be subpoenaed. It's going to be part of that process too, right? Whenever you go on those subpoenas, what is it that they're asking you to do?
Go to court.
Yeah, you need to be somewhere at a specific time and you need to provide something, usually, right? Whether it's you need to be there to answer questions, so you need to be there ready to answer questions, or you need to be there. Well, brother, that subpoena process is compulsory. You have no choice. That subpoena process includes language, meaning you will have to speak. You have no choice. The only time you have a choice is when. That's one of those things that's really interesting in society because that's one that, as of late, compulsory speech has been in the social sphere. Some it's like people don't realize we do have compulsory speech in some places. This is it, right? We're going to tell you, you have to come in here, you have to speak honestly, and you have to tell us exactly what happened, unless it incriminates you. That's the one exception, right? Now that can balloon out into a few other exceptions, but not too many. Right? Where's your privacy at? A little bit. Where is married? Then maybe. Go to a doctor, a clergy, or something like that, then yeah, there's some things that they don't have to say. But for the most part, anything that's not privileged, you will have to say, or you're going to face that punishment. Okay. Credibility. There are a number of factors that affect credibility. Each textbook will do them a little bit differently. For the course, this course, run with how they have it here. If you're taking procedures, I'll break it down into a few different things because that I kind of wanted to show you in that class a little bit how it works. We'll talk a little bit about it here too, in terms of timing and some of the stuff that you'll see people have trouble with. But here we'll talk about this. So it says, judge or jury, whoever is the trier of fact, so the jury, sequence trial, they get to determine whether states are believed and what weight to give them. So when you're doing that, you're dealing with credibility. Here they say perception, memory, narration. Perception, the opportunity to observe and perceive it accurate. Memory, retain accurate impression of what witness saw, heard, smelled, so on and so on. Narration, does it describe it accurately? Does it transmit that information accurately? You were in procedures. We talked about it a little bit differently. So I'll talk about, let's see, it's going to be factors like time. It's been a while since I put that course, so I'm trying to remember what exactly I had listed there. But basically, we start getting into some of the limitations of people. Think about eyewitnesses and how flawed they are. Right? If I have an event take place at the front of the classroom with each of you in here, each of you will see something a little bit different just as a byproduct of where you're sitting, right? And that can get worse as you try to interpret things, what actually happened there. And so it's a very, very difficult thing. One of the most interesting things to do is on the procedural side, because if you're trying to like make identifications, that's where it comes up a little bit. Those processes for identifying people, a little bit different than what you'd see here for eyewitnesses at trial. That's going to be because of the fact of those procedures. For example, if you saw, if you had to do a lineup 3 times in a row, right? 3 different dates, X number of days between them, how long before it is that you identify that person who's common between those 3 lineups, right? Is it something you're gonna be conscious of, or is that person just gonna start looking a little bit more familiar while you're thinking about the fact that somebody is trying to victimize you in some way? You're trying to identify that person, right? So then your questions that you had start to change a little bit. Is this the person? Is this the person? And then if you've made the finger, okay, that is the guy. Now you bear a different way. What happens if you're wrong? So most people do. Is as it gets close to trial, they become more certain that that's who it is because they don't want to deal with that psychological burden. And that's one that you do subconsciously. Most people do. Okay. Intracranial, if I can say that. No, I can't say that. Physical facts rule. How's that one? I can say that one. Holds fact-finding body will give no weight to witness statements that are inherently incredible, unbelievable, contrary to physical facts. So basically, you look at it in terms of reasonableness on the other end of things, right? Like, so you're telling me that you were in this room with this person with a gun, and all of a sudden, James T. Kirk appeared in the room. And that's the person who assaulted the dead guy and killed him. I don't believe it. Doesn't seem real. That kind of stuff. It's not going to be quite so outlandish, but you will see that kind of stuff. Yeah, that's not how things work. That kind of thing. So it's something completely incontrovertible. You can just dismiss it. Jury evaluates the weight and credibility of testimony free from the influence of the trial judge. The trial judge doesn't get to say anything about it. Yeah, questions, usually what they'll say is you have everything you need already in front of you. It's a good way to do it. That's your determination. You make that. You can't say anything. Okay. Protecting. So there are a few different ways to deal with children because of the emotional, psychological issues associated with it, particularly with those who are the most vulnerable. Sometimes it'll be testimony given by closed circuit television. Sometimes it can be videotape. Right? Some statutes are revised to make it easier to find them competent. And then got some hearsay exceptions too. Right? Because you're doing some, basically it's like a different animal. People at that stage are not the same thing as people as adults, and we recognize that. That's a good thing. Okay. That kind of stuff. Ways to make communication easier, children, particularly when talking about difficult subjects. Okay. Kicking everyone out of the courtroom too to make it easier for them to talk. Realize though that you have to face your accusers here. How many people are going to use that to their benefit to get that person to shut up? Right. Okay. Leading questions. We'll talk about those at some point in here. I don't remember where they talked about it, if they talked about it yet in here, or if we need to hit it later. Basically, leading questions versus open-ended questions, there are times to use both. And when you use both matters a great deal because what you're trying to do. But here you can use them more to help direct them. And then limiting length of time, limiting number of interviews, because secondary trauma is a thing. Every time they talk about it, they deal with it again. And the other one, handle it quickly so they can move on. Okay. Maryland versus Craig. So when protections for a child witness may include excuse rather than face-to-face confrontation with defendant, face-to-face confrontation with accused and witness is not absolute must. Okay. So that's the one that they got started moving into, like videotape testimony rather than face them correctly, that kind of thing. Yeah. That's not something, that power dynamic is something a kid can't appreciate, that person who might be dangerous to them is no longer dangerous at all in that situation. So yeah, you need to take that into account. Okay, false memory or taint. Here it talks about children. Everybody has it to some degree. Time, attention are very difficult things to manage, right? At any one point in time, you can only have a little bit of bandwidth to actually pick up all the sensory input that you're getting. Now you're dealing with, just with this topic, it's like how many issues come up with that, right? On the side of it's a difficult struggle to remember painful things, to the other side of, hey, I'm a kid that wants attention. Ask me a leading question, give me attention. And I'll have you talking all day. Right? So both those things go on and you have to address that to some degree. Some will let you explore that, some won't. It isn't clear if in that determination that defendant has to be there because of the nature of that relationship. That's a sensitive thing. Okay. Certain taint claim or taint results in child testifying not to what actually happened, but what's suggested at the time. So this is one of more recent, not super recent cases, but to show the influence that the questions have on children. They had a similar issue, I forget what decade it was, number of decades back, where the surfers started getting attention because the fact they're going in and asking people these types of questions, they didn't realize what was going on. They're going to answer them certain ways and interpretations, that kind of thing. What's real, what isn't, it's very hard to determine. Very hard to determine. Next one. Where are we at here? Eyewitness testimony. Testimony, important, yes. Eyewitness identification is unreliable. It's inadmissible. If there's any likelihood of irreparable misidentification. So how bad is eyewitness identification? Yeah. If you have procedures, I'll show you a video where it's a person walking up asking directions and they get interrupted, someone else comes in. Most times people don't pick that on, and that's dealing with someone directly. This kind of thing with the, well, with all the cognitive issues attached alone and how those things can affect your perceptions is, can be overwhelming. To give you an example, my favorite story I've ever heard was it was a rape case. I need to look it up so I can have the citation for it. But what ended up happening was it was, I think late 90s, maybe early 2000s, finally got access to DNA and proved the guy who was convicted was innocent. The eyewitness, the lady who identified him, ended up writing him a letter saying, apologizing for the years of his life he had lost, but also saying, when I have my nightmares, it's your face I see and I'm sorry. That's awful, right? They look somewhat like, it'd be like saying AI stuff. How many times has AI misidentified people for crimes when it's used? Right? People do the same thing. AI's got an algorithm that does it. People just kind of do it. It's a scary thing. Okay. Here we go. That's the one I was looking for. So standards for evaluating eyewitnesses. Tests. Opportunity. That's that time element. Can you view? What can you view and when? Right? How much attention are you paying? That's going to be a big one. Some people are paying attention, some people aren't at any given point in time. I'm not. No, that's me. So that's probably everyone else too. I like to zone out. And it takes a lot of energy to stay focused. It takes a lot of energy to stay focused, especially if you don't know what's going on. Right? Because that's how that's going to typically going to happen unless you know it's going to happen. And the only way you know it's going to happen is you're going to do something. Right? You're going to be caught by surprise if you're witnessing most of the situations. How much attention you're given at any point in time, and realize that if you're the target, that offender is going to be looking for when you're not paying attention. That's how that works. Yeah. Okay. You have the accuracy of all of the descriptions. Right. You're going to have immediately after the incident you file a report, or whenever the report is that you filed. How many details were you able to get down? How much can you remember? What can you remember the next time? What kinds of things change? What kinds of details came in that are new? What kind of details that were old didn't come back? Right? All that stuff moves in those types of directions. Okay. Witnesses' level of certainty. That's something I was talking to already. Usually it's I don't know, I'm uncomfortable. Now I'm starting to feel like I really need to identify somebody. Is that the guy or is that just someone who looks close enough? I can't tell you. I didn't see anything. You're going to have to tell me what you think. That kind of thing. You'll see that tends to happen, particularly as you talk about it more. So think about by the time you get to trial, how many times that person has made that identification, has had to talk about that identification, has had questions about that identification. So yeah, they're gonna seem pretty certain, maybe they're not. I don't know. Length of time between the identification and the crime itself. There's a few different ways they do that. I won't go into the procedure stuff. That would be like a show up where you show like immediately after the scene, we have a description. There's a guy 1 block away that meets that. Is this the guy? Yeah, that's the guy. Right? Or no, it's not the guy. Otherwise you go lineups, photos, that kind of stuff. And how many days is it between the event, the ID? That's time and attention and memory all fade. They're like perishable skills. If you don't use them, they wane. If you use them too much, they strengthen. You strengthen them, but you're going in the wrong direction because you're thinking about the wrong thing. When you're thinking about it, you'll be in that same situation where that lady was, where she's having nightmares about the wrong person. That's serious. All right, eyewitness testimony. We just went through that. That's the same thing. It's just an updated version of it. See, you start out here, length of time, that kind of thing. Here's where it changes a little bit. Opportunity, degree of attention, capacity to observe. Identification was made spontaneously and remained consistent. So there you go. And then the nature of the event being observed, likelihood the witness would perceive it, remember, and relate it correctly. So you start taking in more context. Okay, demeanor. Demeanor is kind of fun. I'm gonna pull a bad joke that I got from one of those gun people. I think in here I mentioned a guy by the name of Masad Ayub. Have I ever mentioned that guy in here? He's a really weird one because he's an expert witness in a lot of defensive shootings. I like this stuff because he'll talk about stuff directly. One of the ones he'll talk about is this one. He's like, realize that sometimes the people in here aren't doing anything more than putting on a show. If they put on a show that's good enough for people, they'll convict you. And so he starts out the joke. He's like, he's asking an officer questions, and the officer's answering. He's like, in the middle of it. So, when was the last time you had sex with a chicken? Something like that. And it's like, never. He's like, wouldn't that outrage you? I don't see any feathers on your pants or anything like that. I would think that would get me a little bit upset. It's like, the hell are you asking me that kind of a question for? Start showing that demeanor, start being a real person, start being real honest. Show that you're afraid. And guess what? You might be. Show that you're not, they're going to wonder why you're not. You're adding in more questions for a jury that shouldn't have them. That kind of thing. Those perceptions are there and you have to be cognizant of them. Right? Quote, Judge Hands ruling. It is true that the carriage, behavior, bearing, manner, and appearance of a witness, in short, his demeanor, is a part of that evidence. Okay, so your appearance. That's a hard thing to judge. Now you see why it's so difficult. Who's being honest here? Okay. Court held that the mask prevented the judge from observing the informer's demeanor and assessing abilities. They wanted to have an informant keep his identity hidden or her identity hidden. That's a common one because as soon as you have a confidential informant testify, they are no longer confidential. So you want to hide those sources, particularly if you're working on something big. Right? You don't need to burn your sources because that's your avenue in. That's your avenue in they're dealing with larger issues, larger scales, bigger problems. You're taking care of this one singular case. I'm going to burn one of those people. Is there a way around that? Now you need to be able to see them and you face your accusers. That's more important because it's innocence that's important, not guilt. Okay, State versus Hernandez. Upheld decision to allow an undercover to wear ski mask. That's good. where held that face was not required, where satisfactory reason exists. So you can limit it. I'm not as familiar with that because I don't follow that stuff as much. That's one that's, if you have an adequate justification, you want to be mindful of what those thresholds are. So you want to look to those cases to see what that is in this case, and then try to find something that parallels it if you want to use it, or find something distinguishes your specific case from that determination if you want your accuser to face you without a mask. That's funny. Okay. In order to qualify as a witness, relevant information, competent, willing to testify the truth, be competent. Remember, distinguish fact from fantasy. No, you must tell the truth. Very simple stuff. They're just emphasizing that there. Evaluating accuracy. Okay. How we keep people honest. You have your oath. That's at the forefront. You have people who are trying to find the facts, disaggregated across people, spread out. Aggregate. You get to be cross-examined. So I can question you to see if there's any holes in what you're saying or invalidate. If I do something knowingly wrong, I can be punished. So there's a lot of reasons to stay honest. Okay, what happens if you forget something? Should you be punished or unable to relate information you can't remember? It's important to the case, and there's evidence to such. You can do stuff like this. You can prompt someone verbally, or you can give them something to prompt them. In the absence of that, you can give something else that kind of establishes it on its own. That kind of thing. Basically, it's a way to refresh memory. It's also one of the reasons why if you listen to like any type of deliberations, discoveries, that kind of stuff, those processes, you'll hear something to the effect of, I cannot remember at this time. It's a good way to not answer a question while answering a question without specifying anything that will be later held against you. Because if you get one fact wrong, that might be held against you later. It wasn't 5:15, it was 5:10. You're lying again. Why are you lying? That was all. About 5 minutes. That 5 minutes is pretty consequential, don't you think? That's how it works. Okay, vouching. All courts agree that there's exclusive function of the jury. One consequence of this rule's prohibition of courts called vouching. Occurs when credibility of witness is enhanced by someone else. You can't vouch for someone else. That's a holdover. That's one of those things that if you looked at old systems, it was if you had one person, how many poor people would it take to be that of a lord, right? How many people you just say this actually happened in conflict with someone who had actual authority there and they weren't equal? That's bad. All right. Here's where I start talking about subpoena stuff. We'll get into that next time since we're out of time. What do you guys think? A good class day? You get some stuff, we're moving some stuff pretty fast. Will be fun when we get to the expert witnesses. I'll show you some stuff there. Talk about that a little bit about the whenever they stipulate it. But we'll talk about the processes for doing it. Effects of it. Cool. All right. Well, I will catch you all next time. Don't forget about the exam, any quizzes that might be out there, anything like that. And if you have anything you need, just let me know. I'll be catching up with you. I'll get these videos out as soon as I can. I am behind on that. I'm always behind. But at some point in time, I'll be so far behind, I'll actually look like I'm ahead of it because it'll flat for me. At any point, I'll talk to you guys next time. You take care.